Let's talk about the self-defense claim that was made by the ADA Binger yesterday. And I know you are literally the expert in self-defense. So let me play soundbite 4 and get your reaction to whether this is a misstatement of the law.
Convince you that Joseph Rosenbaum was going to take that gun and use it on the defendant because they know you can't claim self-defense against an unarmed man like this. You lose the right to self-defense when you're the one who brought the gun, when you're the one creating the danger, when you're the one provoking other people.
Is that true or false?
Well, of course, he mixes a few different things in there. If you actually provoke the confrontation, well, then arguably you do lose self-defense, but you don't have no right to defend yourself against an unarmed person. Hundreds of people in America are killed every year with fists and boots. So an unarmed person can readily be a deadly force threat against which you'd be privileged to use a gun in self-defense. And you certainly don't lose self-defense if you bring a gun with you. I carry a gun for personal protection every day, have my entire adult life. I have the same privilege of self-defense as anybody else.
The provocation for Rosenbaum's killing seems to be this allegation that Rittenhouse pointed his gun against a man named Zeminski earlier in the evening. Zeminski chased Kyle Rittenhouse after that, and so did Rosenbaum, and then that confrontation took place. With respect to the two others that Kyle shot, Grosskreutz and Huber, what's the provocation? Is it simply the killing of Rosenbaum and the failure to lie down right there saying, surrender, surrender, I shot him, get police?
Right, that's the state's narrative. So basically, it's kind of the fruit of the poisonous tree idea. If the shooting of Rosenbaum was wrong, then every consequence that happened after that is the fault of Kyle Rittenhouse, is the state's position. But they had to go to this provocation argument because of the inherent weakness in their case. I mean, there's really two ways to attack a claim of self-defense. And by the way, which the state has to disprove beyond a reasonable doubt. One is to attack the elements of the self-defense claim itself. That's effectively impossible here because all the video, all the evidence is consistent with lawful self-defense for every one of these criminal counts. So that's not likely to work. Well, if you can't attack self-defense that way, you tip over the whole chessboard by arguing provocation, because if someone provoked, well, then they don't have a privilege of self-defense. You don't have to worry about the legal elements of that legal defense anymore. But their argument for provocation was, I mean, frankly, it was pathetic. They have this, as Richards put it, a very good part of his closing, the hocus pocus out of focus photos that were laughable. And the only other human being who could have provided evidence about provocation was Joshua Zeminski. And the prosecution very carefully charged him with arson so that he would be on ice, so that he would have a Fifth Amendment privilege not to be called as a witness by the defense in this trial. So there's really no evidence in support of provocation that could prove provocation. Remember, the state has to prove it beyond a reasonable doubt. They're not even close to that threshold.
Mm-hmm. There's one charge relating to this guy who's referred to as jump kick guy, saying he was recklessly endangered because Kyle shot at him but missed. He jump kicked Kyle in the face right before Anthony Huber came up and started beating Kyle with his skateboard. The shooting of Huber, and Huber did die, is charged as the intentional homicide. That's the most serious charge of all. And they don't even seem to be arguing that Huber wasn't... That Kyle didn't have the right to use self-defense against Huber, other than just saying Huber was the good Samaritan, Kyle was still an active shooter. Because unlike with jump kick guy, they're like, okay, jump kicking that's not really deadly threat against Kyle. And even on Gage Grosskreutz, they're saying, no, he didn't actually pull the gun on him. It was only once he was shot that his arm involuntarily went towards Kyle, undermined by Gage himself, who took the stand and said, no, I pointed the gun at him, and that's when he shot me. But it seems to me that with Huber, they have no argument that Huber didn't put Kyle in fear for his life. No argument at all that beating Kyle with a skateboard didn't give Kyle justification for believing his life was in danger. Their only argument on their most serious charge seems to be you provoked the whole situation.
That's right. And there's something else here that I think the defense had really pushed harder on. With all these attacks at the second scene, He was perfectly justified in using force. If those had been individual, isolated attacks, any one of them, he would have been entitled to use deadly force in self-defense against those attacks. But they weren't isolated individual attacks. His perception of the threat is based on the totality of the circumstances. So it's the collective threat of all those attacks, even the people who ultimately didn't come in, but appeared initially to be coming in with clubs and other weapons, who backed off when they saw that Kyle was still prepared to defend himself. That's all a collective threat, certainly a collective threat capable of readily inflicting death or serious bodily injury.
I want to give a soundbite from Binger on that sort of sequence I just discussed with you on Huber, on Jump Kick Man, on Gage Grosskreutz, because we spent a lot of time earlier talking about Rosenbaum. Now, this is the second half of the story. This is soundbite 9, Binger in his closing argument.
The crowd has the right to try and stop an active shooter. Anthony Huber comes up with a skateboard and the defendant blocks it with his arm, and then the defendant falls to the ground on his own. No one knocked him down. This man that the defense wants to call Jump Kick Man, he's got no weapons, no gun, no knife, no nothing, comes in and tries to kick the defendant in the face. Anthony Huber comes back and tries to grab the gun, actually does grab the defendant's gun and tries to pull it away because he's trying to disarm an active shooter. Gage Grosskreutz had his own gun in his own hand. He could have aimed it and fired at the defendant, but he did not. And you heard Gage Grosskreutz testify about that, about how that is a decision that he was not prepared to make at that point in time. He is not the type of person who is just willing to take someone's life in an instant, unlike the defendant.
Your thoughts on that?
Well, of course, the whole thing is laughable. But here's the risk. And the risk is not that serious people, a genuinely fair and impartial juror would take this seriously. That's not likely to happen. The risk here for Kyle Rittenhouse is that there's somebody on the jury who's what I would call an interested juror. They're interested in convicting Kyle for whatever their own reasons might be, political views, whatever it might be. They're not willing to do it if there's zero rationale to convict, because he'll go to prison for the rest of his life, and you need more than a zero reason to do that. But they'll justify the conviction if there's any reason, the slimmest thread of a reason that they can justify to themselves with coming back with a guilty verdict. And that's what Binger is doing here. He's holding out not something that's substantive, that's proof beyond a reasonable doubt. He's holding out this thin reed to that potential interested juror in the hopes he can't convince 12 jurors like that. But if he gets one, he gets a hung jury. And normally a hung jury is, I would call it a win for the defense, because at least your client didn't get convicted. But normally your client's not as innocent as Kyle Rittenhouse. A hung jury here is a win for the prosecution, because they'll just do the whole thing again and again and again until they've ground this poor kid into dust.